This is a very important topic. I would argue that your powers of attorney are some of the most powerful and important documents you will ever sign. So really considering how to choose the right agent who will make decisions for you in the event you cannot or need help with your finances, help with medical decision making, are just of tantamount importance in terms of the things we don't want to happen and we hope for the best, but they are extremely important documents to have on hand in the event you are incapacitated. To begin, I'm Kate Silburn. I'm an elder law attorney. I own Rocky Mountain Elder Law. I've been in business with Rocky Mountain Elder Law for 6 years this month. And we do comprehensive estate planning. We do guardianships and conservatorships for at-risk adults and minors. And we also do probate administration and litigation. I am a Colorado native to a certain extent. I moved here when I was a small child, so technically not a native, but grew up in Crested Butte and lived abroad and in New York for many years and practiced in New York and returned to Colorado about 23 years ago and have been practicing law here. I did briefly leave the practice of law to run an institute for Denver Hospice. I'm also a hospice chaplain and have worked in the hospital setting as a chaplain as well. So as we go through this presentation, I'm sure you'll pick up that some of that chaplaincy and that work with patients and their families informs the way that I practice law and informs the way that I think about end-of-life planning, planning for last illness, and planning for dementia. It's all part of the estate plan that I do, and I'm very committed to people articulating and expressing their wishes for their end-of-life care long in advance of needing to execute those wishes. So let's begin. What we will cover today. We're going to look at the different types of powers of attorney, the role of an agent, key traits to look for in an agent for a financial power of attorney, tailoring financial power of attorney authority. We're going to be looking at key traits to look for in an agent for a medical power of attorney, how to protect yourself. And of course, because I'm a lawyer, we'll look at what can go wrong and what can be done if something does go wrong. So let's look at generally the different types of powers of attorney. You've probably, if you've been in a hospital setting with a loved one, or if you have yourself undergone major surgery or those kinds of things, the hospital has probably asked you for a medical power of attorney or asked you to fill one out. And so many of you may have familiarity with that document. Agent under a medical power of attorney makes healthcare decisions if you're incapacitated or cannot articulate your wishes. An agent under a medical power of attorney ensures your medical wishes are followed. Contrast that to a financial power of attorney, also known as a general power of attorney. In that power of attorney, it concerns solely property. And I mean everything you can imagine to do with your property. And that includes finances, assets, and accounts. It can be a broad power or a limited power. It can be a power that only comes into effect if you're incapacitated, and we'll talk about that. Or it can be what's called a standing power. And a standing power is where the agent under that power of attorney has the ability to be on your accounts, has the ability to help you with finances, as soon as you sign it. And the reason that may be a good idea is because people need help with their finances long before they're incapacitated. This is a very important distinction. It's called a standing power versus a springing power. A medical power of attorney is one that springs into effect upon your incapacity. As long as you can articulate your medical decisions, you get to make them. So, in a financial power of attorney, there are several different types. A durable power of attorney gives the agent all of the powers of a general power of attorney, but also contains a durable clause that maintains the power of attorney after you become incapacitated. So durability can mean it lasts until death, and it also lasts through incapacity. It's important to have your power of attorney be durable unless you decide that you only want it to spring into action upon your incapacity. But that, of course, requires doctor certifications and or a court adjudicating you to be incapacitated. It can be a very burdensome process to make that power of attorney come to life if it's a springing power. There are circumstances where that is a good idea. For instance, if someone feels that the agent they've chosen should only be able to act if they are incapacitated. Again, the way that I write, the vast majority of my durable powers of attorney, they are standing powers because, again, one usually needs assistance with finances long before they become incapacitated. So we have the durable power of attorney, we have the springing durable power of attorney. I've written springing durable powers of attorney where there is a requirement that a panel of doctors certify that someone is incapacitated. This can be incredibly difficult to obtain from, say, 3 different doctors, but people do this as a result of being extremely nervous about their agent having any control over their finances. And we're going to talk about the selection of an agent in just a moment. There are also special or limited powers of attorney. In this instance, the agent has only specific powers limited to certain area or action. This could be a power to sell a home or other real estate, but again, extremely limited and tailored to a specific task. So let's get to the role of an agent. Being an agent is a legal responsibility. It is not a reward. In other words, your favorite child is not necessarily the best agent. Not that we play favorites with our children, but your favorite nephew or niece or the one who has done the most for you, that may be the best person. But oftentimes there can be some tension amongst children or nephews or nieces or friends or neighbors about who gets to be the power of attorney. It's not a who gets to be it, it's who is the best person. Agents must act in your best interest and follow the law. It is not a position to appoint to someone who is not of that mind, who doesn't take the responsibility very, very seriously. In fact, there are laws that provide for civil and criminal liability if someone doesn't behave as an agent under a power of attorney. If a family member is not suited for the role, consider professional options such as a professional fiduciary. I am a big fan of professional fiduciaries because they take the family dynamic out of, for instance, financial decision-making and put it in the hands of someone who is bonded, insured, and has a succession plan. If someone you appoint should pass away, or you haven't appointed a successor, if it's a professional fiduciary, succession is built into that nomination. So there's several reasons that a professional fiduciary may be a very good idea. It takes the quote unquote competition out of the whole dynamic of your choice of agent. On the other hand, if you do have a child or a nephew or a close friend who is a CPA or even an attorney, if they'll accept, that can be a good decision. But the point of all of this is to really consider who you choose, what their skill set is, how serious their mind is in terms of what they understand the role to be, and their willingness to follow the law. So what are the key traits to look for in an agent for a financial power of attorney? Trustworthiness is obviously the number one. The agent must act in your best interest. Putting aside self-interest is the number one characteristic of an agent. Competence, they should understand finances and legal obligations. So they should have a level of sophistication when it comes to whether it's balancing books or understanding how to balance a checkbook, how to keep funds segregated. One of the most important things about competence is to never commingle your finances with their own. Responsibility. A history of managing finances well is crucial. And then finally, a fiduciary duty. For those of you who don't know, a fiduciary is someone who must act in the interest of someone other than themselves. And that means we must act according to the law as it's a role, excuse me. I'm sorry, someone came into my office. They should act at all times according to fiduciary obligations. So a fiduciary duty, someone is a fiduciary who's an executor or personal representative of an estate. Someone is a fiduciary who is a trustee of a trust, an agent under a power of attorney. These roles are codified in law, meaning there are statutes that govern their obligations. And there's also solid case law affirming those statutory, legally defined obligations. So if there is no family member available, consider a professional fiduciary because they understand what their legal obligations are as well as their ethical obligations as a financial power of attorney. So a financial power of attorney can be tailored. There is in my form, and it's the statutory form in Colorado, so many attorneys use it, general powers. So there's a general grant of what you can do with property, and it's exhaustive. There is just everything you can imagine to do with property in terms of real estate, finances, that kind of thing. But then there are specific powers that are delineated, and those concern the creation of a trust, the funding of a trust. Those concern gifting under the Internal Revenue Code or the Colorado statutes governing the same. They concern the revocation or acceptance of beneficiary designations, of joint tenancy arrangements. So the specific powers are really detailed, concern estate planning, gifting, the ability of your agent to appoint successor agents, all those kinds of things. I generally recommend the trust provisions because it may be necessary for your benefit to create a trust down the road if you don't already have one, for the purpose of obtaining public benefits, that kind of thing. But there's also a provision in the specific powers that concern digital assets. I encourage people to include those because your agent will need access to your digital devices in order to manage your affairs effectively. And then the other ones I discuss in detail with my clients to make sure that they want their agent to have those more specific tailored powers. But I really do sound a note of caution about giving those specific and broad powers unless the agent is fully trusted. And I always really encourage deep discussion about any concerns you have about your agent or the powers you're setting forth in that document before you finalize or sign anything. A financial power of attorney is not something to rush through or to have someone say, sign this so I can do XYZ. You want to be very careful, especially of the 1 or 2 page financial powers of attorney that you can get online. And I say that because they're very broad and they can really give over, in a way, too much power. And it's not a consideration to be done quickly. So let's turn now to the medical power of attorney. We want to really be thoughtful about this. Most people, if married, choose their spouse, and I understand why. It's your spouse. But does your spouse know, and this is important for whomever you appoint as an agent under a financial power of attorney or an agent under a medical power of attorney, have you spoken to them? Do you know whether or not they're willing to serve? It's surprising that some spouses do not want to be put in a position of agent under a medical power of attorney. Sometimes it's better to have a child or a friend, because the number one thing that your agent under a medical power of attorney must do is respect your wishes. But how can they do that if they don't know them? One of the ways to clarify your wishes regarding your health care on a last illness or with dementia or a terminal situation is to articulate those wishes in documents. When you do that, when you do an advance directive or a living will, when you do planning for dementia, you are giving a gift to the people who love you. You are lifting out from them those very difficult decisions. And you are saying, this is how I want it to go. So your agent is essentially an enforcer of those directives. You want someone who's emotionally strong, who can handle tough medical choices under pressure. You want a good communicator, someone who can speak effectively with doctors and family. And above all, and this ties in with respecting your wishes, you want someone who understands your values. This is especially important for end-of-life care. We want someone who we've had the tough conversations with, that in this situation or in these circumstances, I would not want to be put on a respirator indefinitely. That's just for example. or I would prefer not to have artificial hydration and nutrition if it were an option. So the big tip here is to have open discussions about your preferences in advance. One of the things that I found in my practice is that many family members, including spouses, do not want to have these conversations, do not want to do this type of planning. And I understand that, and I have an enormous amount of empathy and compassion for that. These are not documents we ever want to have to use. It's kind of like a will. We hope it never comes into effect, but I'm pretty sure mortality is 100% likely. So we do them and we still hope for the best, but we plan for situations that may occur with our directives and in the choice of an agent for a medical power of attorney. The truth is, it may not be needed, but more and more as our population ages and people have a period of decline before they pass away, these documents become ever more important. And on a final note about that, in the absence of a medical power of attorney and a financial power of attorney, if you become incapacitated, then your loved ones must seek what's called a conservatorship. That's a financial decision maker, or a guardianship, which concerns your health care and well-being from a court, the court in the county in which you live. That is a much more time-intensive and expensive endeavor than simply getting your powers of attorney done. They become ever more important. The financial power of attorney, because the people who care about you need to make sure your bills are paid, that you are provided care and your care is paid for. With a medical power of attorney, my recommendation is that anyone over 18 years of age should have one. And this past year, my son finished high school and turned 18, and many of his colleagues went off to college. He is living at home going to college, but even so, they need to have a medical power of attorney so their parents can communicate with healthcare providers about their medical care. Because of HIPAA and the privacy laws, which prohibit the communication with someone other than the patient, unless there's a medical power of attorney or a HIPAA release. I do both, by the way, when I do a medical power of attorney. Those documents are critical in an emergency situation and critical as we decline. So how to protect yourself? We want you to choose trustworthy agents that you have communicated with and let them know that you are choosing them. We recommend, when I say appointing multiple agents for oversight, this is what I mean by that. With a financial power of attorney, say you name one agent, but then the other two siblings you have in the document as being recipients of regular reporting and accountings. So you can have a way to safeguard whomever is acting as agent and make sure there's accountability in several levels. So that goes to the regular financial reporting to trusted family or advisors. Have ongoing discussions about your wishes, whether they be financial or medical, and ensure that family members understand your decisions. Consider legal guidance to safeguard your estate. So we've talked about how to choose an agent and the powers of attorney generally. What can go wrong? Well, an agent under a financial power of attorney may drain bank accounts, sell property, or transfer assets for personal gain. That is a risk. And that is where trust comes in, and that is where a professional fiduciary may be the best choice. Misuse of funds for their own benefit instead of acting in the best interest of the principal. The principal is the person signing the power of attorney. The agent could conceivably alter not so much your will, but other estate planning documents, beneficiary designations, or trusts to redirect inheritance contrary to your wishes. They could neglect financial responsibilities, leading to debt, foreclosure, or other legal issues. Once money is gone, it can be hard to recover, requiring costly and complex legal action. So in other words, what can go wrong? Plenty can go wrong. But that doesn't mean you shouldn't have these documents in place. This has to do with your selection of an appropriate agent, an agent who will act in your benefit. So what can be done if things go wrong? Well, the statutes provide for, in an emergency situation, and even when it's not an emergency, an investigation into the alleged misconduct. In Colorado, we have mechanisms in the statutes that govern the conduct of fiduciaries, including agents under powers of attorney. We also have a very powerful law in Colorado that concerns the protection of what are called at-risk adults, and that's anyone 70 or over. I sat on the State Board of Human Services for 8 years under Governor Hickenlooper, and we developed the statute. It requires mandatory reporting of various professionals if they suspect financial exploitation, abuse, or neglect of an at-risk adult. And so that law is a very good mechanism in addition to the statutes that cover powers of attorney and agents thereunder. So if it's an emergency, the court can take action without prior notice of proceedings. And notice, I mean, to the agent who's misbehaving. They can suspend those powers. The agent can be removed. They can be sanctioned or surcharged for their conduct. There can be contempt of court proceedings against agents. And trust me when I tell you, no one wants breach of fiduciary duty on their record. It is worse than a bankruptcy. It's worse than an eviction. That kind of malfeasance is deemed to render someone who does these things tantamount to just believe me, it's not something anyone wants on their record. We also have had under that statute regarding the exploitation of at-risk adults, involved the police. Sometimes Adult Protective Services is involved, and sometimes the prosecutor takes up these cases and prosecutes. Just so you know, if you are an agent under a power of attorney, we intend to do another webinar about what happens if you're made an agent and how to protect yourself from any kind of allegations of misconduct or malfeasance regarding a principal, the person who signed the power of attorney and made you agent. It's important that before you name an agent, you talk to them. You would be probably shocked to know that I have had many people come into my office and say, I never knew I was named agent under powers of attorney or personal representative, used to be called executor under the will. So that communication piece is extremely important. because some people don't want the job, and understandably so. And again, that can be where professional fiduciaries come in and can be extremely important and effective, cost effective. And again, taking any of the will they do the right thing kind of out of the equation. So this has been uh, a lot of information, but just to kind of wind things up, how do you talk to your family about choosing an agent for a power of attorney? Especially when the family does not want to have tough conversations about decline or failing health or ultimately death. That is the really one of the biggest questions that I get. And I think that it has to be done in a fairly serious manner. This is not an off the cuff conversation. This is, in my view, more of a family meeting, and one where people get to talk about, even their feelings about not wanting to talk about this, but people, you particularly get to say that you are doing some estate planning and you are wanting to really consider who will be your decision makers and really get a feel for who is willing to serve and if they have an understanding of what it means to serve in those roles. But your family, in my view, should be included in your consideration of who becomes your agent. And if there's not a good candidate in the family or amongst friends or neighbors, please consider at least talking to or interviewing a professional fiduciary. I think one can be surprised by what can be handled effectively and cost effectively so that estates and personal issues can be handled in a way that is cost effective and takes sort of the family drama out of the equation.